Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. First off, my apologies for the lack of content this week. I did put up a community post, but for some reason they don't actually give you the notification until like way later. So I don't know how that all works on YouTube. Seems to be like I post it now or early today and then it doesn't come up for like hours. So again, my apologies for that. I have lots of stuff I'm trying to get to. It's just been a little crazy with work and the running and all that sort of stuff that I'm doing. So I am going to jump back into getting through these responses from the state in the case against Stephan Sterns because, well, it's less than a month away is the trial. So I don't know about you guys, but I am ready to go and I'm hoping for it to not get delayed again. I mean, it got delayed by one day. It moved it out. But other than that, let's get this show on the road. Okay, so I believe we stopped last time. We got through the state's response to defendant's motion to exclude any and all victim impact evidence. So we're going to jump to the state's response to defense's motion. Let me pull it up here. This is the state's response to defense's motion to enjoin the prosecution from using witness statements or testimony from other witnesses in preparing witnesses to testify or give statements and from preparing witnesses together. That is a long motion title. I don't know about you guys, but I haven't read one that long. Comes now the state of Florida buy-in through the undersigned assistant state attorney and states and alleges as follows. The defendant requests this court to allow him to invoke the rule of sequestration at this point. That's what this is, sequestration. Here we go. At this point in the proceedings and to prevent the state from, if needed, refreshing a witness's recollection with items not generated by that specific witness. The defendant provides no authority to support his request, and the authority in place requires this court to deny defendant's motion. In making this request for the rule of sequestration to be applied forthwith, the defense has overlooked Florida statute 90.6161 2020, which clearly defines when the rule may be invoked. The statute states, at the request of a party, the court shall order or upon its own motion the court may order witnesses excluded from a proceeding so that they cannot hear the testimony of other witnesses except as provided in subsection 2. It is well established that the rule applies to trials and other proceedings in which witnesses may be called to give testimony in court. In Lambert v. State, the 5th District Court of Appeals said, it's within the discretion of the trial judge to invoke the rule of sequestration after opening statements. 560 Southern 2D 346, relying on cases interpreting the corresponding federal rule of procedure, the court in Smith v. Southern Baptist Hospital of Florida, Inc., 564 Southern 2D 1115, prior to the enactment of Florida Statute 90.616 in 1990, held that the rule of sequestration did not apply to discovery depositions. It is clear from the wording of Florida Statute 90.616 that the rule of sequestration does not apply to pretrial meetings between attorney and witnesses. Accordingly, the defendant's request is premature until trial or other hearing during which a witness will be called to give testimony. The defendant also asks this court to enter an order preventing the state from using any document not generated by the witness to refresh that witness's recollection, and the request appears to focus on pretrial preparation rather than trial. The defendant again fails to cite any authority in support of his position, and again, his request is contrary to the long-standing legal precedent. In Wilcox v. State, 143 Southern 3D 359 378-79, the Florida Supreme Court explained, We conclude that the trial court erred when it prevented Wilcox from attempting to refresh Rickadua's recollection with either the summary of Jean's statement contained in the arrest affidavit or Jean's actual statement. When a witness testifies that he or she has no present recollection or memory of a fact, a party may show the witness in writing or other object to attempt to refresh the witness's recollection. We hear this all the time. We see it all the time in court. KEA versus State, 802 Southern 2D, 410, 411. When a writing is used only to revive present recollections of a fact, it is not required that the writing be written by the witness. Garrett versus Morris, Kirchman and Co., Inc., 336 Southern 2D, 566, 569. In fact, if the witness's memory is jogged and the subsequent testimony is based upon an independent present recollection of the fact, that which prompted the witness's memory is immaterial. See Volusia County Bank versus Bigelow, 45 Florida, 6338, 33 Southern 704, 706. It's immaterial what constitutes the spur to memory, as the testimony, when given, rests solely upon the independent recollection of the witness. Furthermore, writings or objects used to refresh the memory of a witness need not be admissible evidence. See Garrett, 336 Southern 2D at 569. As a corollary to the rules allowing such wide latitude in the choice of writings as mnemonic aids, the writings used to prompt recollection are not necessarily admissible in evidence themselves. Here, the trial court prohibited Wilcox from refreshing Rickamanda's recollection with Jean's statement because this is not a statement directly attributed to this witness that can refresh her recollection as to what she knew and what she said. This is based on somebody else's police reports, and arrest affidavits are not admissible evidence. You can use it to refresh the recollections of officers who wrote it to determine whether or not there were other matters they may have missed. This witness cannot be refreshed or impeached based upon a statement that she did not make. That clearly refers to Mr. Jean, not Miss Curry. Emphasis supplied. Thus, the trial court prohibited Wilcox from attempting to refresh Rickamanda's recollection solely because the evidence was the statement of another individual and was not itself admissible evidence. This was an error. See Garrett, 336 Southern 2D at 569. Wilcox, 143 Southern 3D at 378 through 79. Emphasis in original. There is no prohibition to either party using anything to refresh a witness's recollection, either pre-trial or during trial. Therefore, defendant's statement that sharing of memos and reports among witnesses not only violates evidentiary rules against the admission of hearsay, but further violates a defendant's constitutional right to confront his accuser and test the evidence against him through cross-examination, is contrary to well-established precedent and simply incorrect. Wherefore, the state requests this court deny defendant's motion to enjoin the prosecution from using witness statements or testimony from other witnesses in preparing witnesses to testify or give statements, and from preparing witnesses together. I certify that a copy hereof has been furnished to Elizabeth E. Borden and Division 301 at Circuit 9 Org, and signed by Mr. William Robert J. So that's that one. Then we have the next motion response. All right, so this one is the state's response to defendant's motion to declare Florida's capital sentencing scheme unconstitutional as violative of the 8th Amendment, corresponding article, looks like Article I, 17 of the Florida Constitution, and evolving standards of decency. Man, there's some typos here, y'all. Okay, comes now the state of Florida by and through the undersigned assistant state attorney, and states and alleges as follows. 1. The governing laws in this case are the United States Constitution, the Florida Constitution, and the applicable Florida statutes. 2. While many oppose the death penalty for religious or non-religious reasons, many support the death penalty for religious or non-religious reasons. 3. The Florida legislature, duly elected by the voters in the state of Florida, have deemed that certain defendants qualify for a sentence of death. Florida Statute 782.04 and 921.141, 2022. So long as these statutes do not run afoul of either the United States Constitution or the Florida Constitution, they are the law of the land in Florida. 4. Florida Statute 921.141 does not violate the Florida or United States Constitutions. Lawrence v. State, 308 Southern 3D 544, 551 through 52, Florida 2020. 5. Therefore, the court should deny the defendant's motion. And this is certified and signed by Mr. William J. Okay, let's jump to the next one. See, again, they all say like they're 1 or 2 pages, and then they are not all that way. All right. So here is the next motion response by the state of Florida. State's response to defense's motion to declare 9.21.141 Florida statutes unconstitutional and to bar state's use of the hearsay evidence at penalty phase. Comes now the state of Florida buy-in through the undersigned assistant state attorney and states and alleges as follows. Argument. Defendant challenges the constitutionality of Florida statutes 921.1411 and the admissibility of hearsay during the penalty phase, the constitutionality of a statute and interpretation of a provision of the Florida Constitution are questions of law subject to de novo review. Lewis v. Leon City, 73 Southern 3D 151, 153. See also City of Fort Lauderdale v. Dar, 185 Southern 3D 1232. 1234. The constitutionality of a statute is a pure question of law subject to de novo review. As in all constitutional challenges, the statute comes to the court clothed with the presumption of correctness, and all reasonable doubts about the statute's validity must be resolved in favor of constitutionality. ID at 1234. See also Florida Department of Revenue versus Howard, 916 Southern 2D 640 and 642. While we review decisions striking state statutes de novo, we are obligated to accord legislative acts as a presumption of constitutionality and to construe challenged legislation to effect a constitutional outcome whenever possible. The specific standard for admission of hearsay during the penalty phase is abuse of discretion. Clark v. State, 613 Southern 2D 412 and 415. Also see Chandler v. State, 534 Southern 2D 701, 703. Defendant has not demonstrated an abuse of the trial court discretion regarding hearsay testimony. Defendant argues Florida Statute 921.1411 is unconstitutional in that it allows hearsay in violation of the Florida and United States Constitutions. The Florida Supreme Court has specifically rejected this claim. Chandler 534 Southern 2D at 702. The Sixth Amendment's Confrontation Clause guarantees an adequate opportunity to cross-examine adverse witnesses. There is nothing in subsection 921.1411 which denies a defendant the right to confront the state's witnesses. Internal citations omitted. Hearsay is admissible during penalty phase proceedings provided the defendant has a fair opportunity to rebut the testimony. Owen v. State, 986 Southern 2D 534, 558. As revised on denial of reg. July 10th of 2008. See also Rodriguez v. State, 753 Southern 2D 2944. Under section 921.141, the linchpin of admissibility is whether the defendant has a fair opportunity to rebut any hearsay arguments. Clark 613 Southern 2D at 415, subsection 921.1411, Florida Statutes 1989 allows the introduction of hearsay in penalty proceedings, provided the defendant is accorded a fair opportunity to rebut any hearsay arguments. Perry v. State, 441 Southern 2D 606, 608. If the defendant is given a fair opportunity to rebut it, hearsay evidence is admissible in the penalty proceedings. The Florida Supreme Court in Owen, referencing its opinion in Bowles v. State, 804 Southern 2D 1173, explained when a defendant challenges the admission of hearsay testimony during a penalty phase, this court examines whether the defendant had the opportunity to rebut the hearsay. That the defendant did not or could not rebut this testimony does not make it inadmissible. Owen, 986, Southern 2D at 559. See also Clark, 613, Southern 2D at 415. Clark had the opportunity to rebut any hearsay presented by the state. That he did not or could not rebut this testimony does not make it inadmissible. Chandler, 534, Southern 2D at 703. That Chandler chose not to rebut any hearsay testimony does not make the admission of such testimony erroneous. A closer look at the court's decision in Chandler is intrusive. In Chandler, the Florida Supreme Court analyzed a defendant's right to cross-examine adverse witnesses under the protection of the Confrontation Clause in the context of Florida Statute 921.1411. Chandler, 534, Southern 2D at 702. The defendant argued that Statute 721.1411 was unconstitutional, both on its face and as applied, claiming it denied him the right to confront witnesses against him. The court held in 921.1411 is constitutional as written, stating there is nothing subsection 921.141 which denies a defendant the right to confront the state's witnesses. The court then turned to the defendant's argument in 921.141 was unconstitutional as applied in his case. ID at 703. During the penalty phase of trial, the state introduced testimony from a detective concerning statements made by other witnesses during trial. The defendant objected, arguing the testimony was inadmissible hearsay, but the trial court ruled the evidence was admissible. On appeal, the court found the trial court did not abuse its discretion regarding the admission of the hearsay testimony. In its analysis, the court said, a resentencing is not a retrial of the defendant's guilt or innocence, because a jury cannot be expected to make a decision in a vacuum. It must be made aware of the underlying facts. Both the state and the defendant can present evidence at the penalty phase that might have been barred at trial because a narrow interpretation of the rules of evidence is not to be enforced. To be admissible, however, evidence must be relevant, and the admission of evidence is within the trial court's wide discretion. Subsection 921.1411 recognizes these principles and provides the evidence which the court deems relevant or which the court deems to have probative values which may be presented. Looks like quotations and citations omitted. Defendant relies on Engel versus State, 438 Southern 2D 803, to support his argument. Engel, however, is distinguishable from the case at hand. In Engel, the defendant argued the trial court erred in considering confessions and statements of a co-defendant during sentencing that were not introduced during trial, and the defendant did not have an opportunity to confront. ID at 813. The Florida Supreme Court's analysis turned on the fact that the statements were made by a co-defendant. The consideration of the confession or statement of a co-defendant is quite different from the consideration of a pretentious report. If the defendant disputes the truth of a pre-sentence report, he has the right to secure confrontation and cross-examination if he wishes to do so. See UC versus State, 383 Southern 2D 219. On the other hand, a defendant cannot require a co-defendant to waive his constitutional right to remain silent and force him to testify during the sentencing procedure. ID at 814. The issue in Engel arose during the sentencing proceeding and is limited to what the trial court considered when rendering its sentence. Florida Statute 921.1411 was not a part of the analysis. The court focused on the defendant's inability to require a co-defendant to waive his right to remain silent and force him to testify, an issue not before this court. Wherefore, the state requests this court to deny the defendant's motion to declare 921.1411 Florida statutes unconstitutional and to bar the state's use of hearsay evidence at the penalty phase. Whew, that was a lot, right? Okay, and again, it's signed by William J. So they're trying to mess with the, obviously, they're really reaching for straws. I mean, I guess at this point, his life's on the line. So we all, think he should be burned at the stake. But, again, that 921.141 statutes is very, very clear. I feel like I learned some things about Florida statutes when we go through all this stuff, so it's really interesting. We may become a YouTube lawyers yet, huh, guys? All right. The next one here is state's response to defendant's motion to allow testimony of the impact of defendant's execution on family members. Oh. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges that. Argument. The United States Supreme Court has held that to be constitutional, the death penalty must allow for individualized sentencing and must allow consideration of any aspect of the defendant's character or record and any of the circumstances of the offense that the defendant proffers as a basis for a sentence of less than death. Lockett v. Ohio, 438, United States 586, emphasis added. Florida law is clear that mitigating circumstances are those circumstances listed in Florida statute, specifically or that are relevant to the defendant's character, his prior record, and the circumstances of the offense. See Gerald v. State, 111 Southern 3D, 778808. Farina v. State, 937 Southern 2D, 6112, 619 through 20. Specifically, the Florida Supreme Court has ruled that the trial court does not abuse its discretion by refusing to allow testimony of the impact on the defendant's family of his potential execution. In Burns v. State, 699 Southern 2D, 646, 654, the defendant sought to introduce testimony about the impact his potential execution could have on his family members, arguing that such evidence was relevant to his character and background. After the trial court sustained the state's objection to such testimony, the trial court allowed the defendant to proffer the testimony of the defendant's sister and 2 daughters as to the effect his execution would have on them and their family members. The Florida Supreme Court held, while we agree that the Burns family relationships and support he provided his family are admissible as non-statutory mitigation regarding Burns' character, this was not the focus of the proffered testimony. The proffered testimony went to establish that death was not an appropriate penalty because of the impact of the execution would have on Burns' family. We find that the trial court did not abuse its discretion in excluding this testimony concerning the sentence Burns should receive. Burns 699, Southern 2D at 654. See also Thompson v. State, 619, Southern 2D, 261 and 266, upholding the trial court's decision to not allow certain defense witnesses to express personal opinions about the appropriateness of the death penalty. So really, this is a big one too. I don't think it's going to be approved either. A significant number of other jurisdictions have ruled likewise. See Woods v. State, 13 Southern 3D, 133, upholding trial court's decision finding that evidence regarding the impact of the defendant's execution on his family member did not relate to the defendant's character or record or the circumstances of the cases and was therefore inadmissible. State v. Chappelle, 225, Arizona 229, 236, P3D 1176 and 1185, holding that evidence of the impact the defendant's execution would have on his young daughter and other family was not relevant to mitigation. People v. Vieira, 35 Cal, 4th, 264, 25 Cal, Repertoire 3D 377 106, P3D 1990, 1009, holding that testimony from the defendant's mother that his execution would destroy her was properly excluded. People v. Armstrong, 183, Illinois 2D 130, 233, Illinois, December 252, 700, and E2D 960 and 971, holding that though the rules of evidence are relaxed in penalty phase proceedings, they are not simply thrown out the window, and evidence of the death penalty effect on defendant's family was inadmissible. Ross v. State, 954, Southern 2D, 968, 1013. Upholding trial court decision to grant the state's motion in limine to prevent testimony regarding the impact the defendant's execution would have on his family because such evidence did not address the defendant's character, record, or circumstances of the offense. William v. State, 168, Southwest 3D, 433, 445. Finding it was not ineffective for failing to raise claim on direct appeal that the trial court erred in not allowing the defendant to present expert testimony regarding the psychological impact on his children if he were to be executed, because such evidence is inadmissible. State versus Hale, 119, Ohio, SD 3D 118 892, and E2D 864 893. Upholding trial court's decision to exclude testimony from the defendant's 3 half-sisters about what they would do if the defendant was executed. Commonwealth versus Harris, 572, PA 489 817, A2D 1033 1054. Holding the execution impact evidence properly excluded by trial court. Roberts versus State, 220 Southwest 3D 521 532. Reaffirming decisions finding that a trial court does not abuse its discretion in excluding execution impact testimony. Defendant cites to Lugo versus State, 845 Southern 2D 74, in support of the admissibility of such evidence. It is important to note that in Lugo, the issue as to the admissibility of such evidence was never litigated. Instead, the challenge on appeal focused on whether the trial court properly weighed such evidence, ID at 115. The court in dicta stated, while the impact that Lugo's execution would have on his mother and children is properly coincidental, it nevertheless does not outweigh the aggravators attached to the murders of Gringa and Furton. The proposed testimony as to the impact defendant's execution on his family members does nothing to inform the jurors concerning the defendant's character, his record, or the circumstances of the offense. The testimony should be excluded because it's irrelevant and because of its prejudicial effect and lack of prohibitive value, which cannot be properly rebutted. The state agrees that the defendant should be entitled to introduce evidence regarding the positive character traits that his family members cherish. However, to allow the defendant to tie those positive character traits to sympathy toward the family members if defendant was to be executed is contrary to the Florida State Supreme Court case law cited above. Wherefore, the state requests this court deny the defendant's motion to allow testimony of the impact of defendant's execution on family members. And this is certified and signed again by William J. All right, so we still have quite a bit more. I don't know how much more I'll get through today, but let's see what we can do. All right, and the next one up is state's response to defendant's motion to allow questions on jurors' religious beliefs during individual voir dire. Comes now the state of Florida by-in through the undersigned assistant state attorney and states and alleges as follows. 1. The parties are allowed to inquire about potential jurors' religious beliefs that would preclude them from following the trial court's instructions on the law. O'Neill versus State, quoting Cannon versus State. This one here is the state's response to defendant's motion for special jury instruction on mercy. Comes now the state of Florida by-in through the undersigned assistant state attorney and states and alleges as follows. 1. A similar request was made and denied in Woodbury versus State, Florida 2021. The Florida State Supreme Court cited to Florida Criminal Standard Jury Instruction 7.11 in quoting, regardless of the results of each juror's individual weighing process, even if you find that sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Quoting Florida Criminal Standard Jury Instruction 7.11. Yeah, I'm going to stop reading the statutes here, guys. So, again, if you want them, they are on the docket here, the actual motions. And if you need any help, let me know. But if you just go to Osceola Clerk's website, you can read it all for yourself. 2. Woodbury proposed a special instruction derived from the federal standard instructions, which added, you may always consider mercy in making this determination. He proposed an alternative instruction that he claimed came from the F ether, which added, mercy itself is sufficient to justify a sentence other than death. 3. The Florida Supreme Court agreed with the trial court's decision to deny Woodbury's requests because the standard instruction adequately informed the jurors of the applicable legal standard. The Florida Supreme Court explained its analysis. When a juror votes for a life sentence, despite finding the aggravators outweighed the mitigators and were sufficient to impose death, this decision is often referred to as a mercy vote. In fact, we have referred to the relevant provision of Standard Instruction 7.11 as the mercy instruction, Reynolds versus State. Thus, the court did read an instruction on mercy, and although Woodbury might have preferred the wording of his proposed instruction, Standard Jury Instruction 7.11 is not ambiguous when it comes to addressing the jurors' options. 4. When it comes to jury instructions, repetition is not required as it serves only to give undue emphasis. Florida Power Light Company versus Robinson, Florida, 1953. In fact, the Florida Supreme Court has warned against the use of repetition by trial courts, instructing juries, holding that there is no reason for saying the same thing more than once, except for the purpose of adding emphasis to the statement. Lithgow Funeral Centers versus Lofton, Florida, 1972. The court went on to note it has criticized such undue emphasis in a number of cases. Lofton, citing Biscayne Beach Theater versus Hill, Florida, 1942, Farnsworth versus Tampa Electric Company, 1912, and Jacksonville Electric Company versus Adams, Florida, 1905. 5. Because the standard jury instruction is a clear and accurate description of the law, there is no need for a special jury instruction. The defendant's request serves only to be repetitive and forces the federal government's interpretation upon the state of Florida when two different standards are used. The jury's sentencing decision is binding on the court. United States versus Henderson, ED, Ohio, 2007. Therefore, a jury's recommendation is binding on the court, citing United States versus Sampson, D. Massachusetts, 2003. In Florida, the jury's decision is a recommendation to the sentencing court. 6. Therefore, the defendant's motion should be denied. Certified and signed by Mr. William J. All right. Next one up is state's response to defendant's motion for real-time transcripts. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. Florida Rules of General Practice and Judicial Administration Rule 2.535 is the controlling authority. 2. The Ninth Judicial Circuit has entered an administrative order in compliance with this rule, 2019-12. 3. Section A3 of the administrative order provides in part, whenever possible, real-time computer-aided transcription shall be used in all death penalty cases. 4. Therefore, the court should inquire to the availability of real-time transcriptions for this trial and provide it if it is available. Certified and signed by William J. I like the short ones. All right. Next motion response from the state is state's response to defendant's motion for personal service on potential jurors who do not respond to their summons and for the court to determine all excusals. Wow. I'm telling you, they are throwing it all at the wall here. I mean, any possible motion, it's like, they're like, let's try this one. Let's try this one. How about this one? Maybe this one will stick. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. Florida Statute 40.013, 2024 outlines which citizens are disqualified from jury service and who may excuse someone from jury service. A trial judge may delegate the task of excusing jurors that are prohibited from serving or that have the option of refusing to serve. Jones v. State, Florida 2nd DCA 2000. 2. A trial judge is not required to oversee every excusal from jury service. This does not deny a defendant's right to be tried by a jury representing a cross-section of the community. Henderson v. State, Florida, 1985. 3. The defendant fails to allege what particular cross-section of the community is more likely to fail to appear for jury service. Florida Statute 40.23, 2021 outlines the process for summoning jurors. There is no requirement for in-person service, and the statute outlines a penalty of a $100 fine or punishment as contempt of court. 4. Also, there's no practical way to do what the defendant requests. We will not know which jurors fail to appear until each day a panel is summoned. It's impractical to suggest we wait for personal service to then be had on each juror under no statutory authority to do so, and then proceed with jury selection. 5. Therefore, the defendant's motion should be denied. Yeah, this is insane. This particular motion, I'm just like, what? Like, he thinks they're just going to go knock on everybody's door or call them and go, hey, you're here for jury duty? You didn't come. I mean, come on now. I mean, that's insane. We know people don't show up. I mean, they can hold them in contempt and fine them, but it's not it's not really done a lot. All right, here's the next one. State's response to defendant's motion for individual voir dire as to death qualification, publicity, and hardship. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. The state agrees that potential jurors should discuss any pretrial publicity individually, not to taint the other members of the panels. O'Neill versus State, Florida 2023. The trial court in this case agreed to individual voir dire of prospective jurors having any previous knowledge of the case, including from pretrial publicity. 2. Hardship and scheduling issues can safely be discussed in large groups. 3. Death qualification questioning can be accomplished with smaller panels of jurors, groups of 5 or 10 at a time. The determination of whether to grant individual or sequestered voir dire rests in the trial court's sound discretion. San Martin versus State, Florida 1998, death qualification. 4. Therefore, the defendant's motion should be granted in part regarding jurors who indicate they have exposure to pretrial publicity and deny without prejudice until the need for individual voir dire is developed during jury selection for hardships or death qualification. Again, certified, signed, Mr. William J. Yeah, he was pretty clear when it talked about like the media, press, and I think it's the same thing when it comes to potential bias that the voir dire is going to solve their issues right there. All right, next up is state's response to defendant's motion for discovery of prosecutorial investigation of jurors. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. Argument. Criminal defendants do have a right to pretrial discovery under Florida Rule of Criminal Procedure 3.220B. State versus Ross, 792, Florida 2001. See also Florida R. Crimp, 3.220B. 4. As soon as practicable after filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant. However, nothing in Florida Rule of Criminal Procedure 3.220B entitles defendant to discovery of the prior criminal history of or information about potential jurors beyond the confines of Brady, which the state has already agreed to disclose. There is no general constitutional right to discovery in a criminal case, and Brady did not create one. Weatherford versus Bursey, 1977. See also State versus Ross, Florida 2001, noting there's no constitutional right to discovery in a criminal case. This is evidenced by the repeated refusal of Florida's appellate courts have repeatedly refused to order the type of broad disclosures the defendant seeks here without first demonstrating his efforts to obtain the information they seek on his own. Both the First and Second District Courts of Appeal have considered and rejected defendant's assertion he is entitled to the prior criminal history of prospective jurors. In Monahan v. State, Florida 1st DCA 1974, the First District Court of Appeal affirmed the trial court's denial of the defendant's motion for discovery of criminal records of the prospective jurors and state's witnesses. Monahan 294 at 402. The Monahan court dealt with the request as to the jurors subsequently. Appellate has cited no authority to support his contention that the state should have supplied him the criminal records of the prospective jurors, as we know of none. The Second District Court of Appeal reached the same result in Robertson v. State, Florida 2nd DCA 1972, affirming the trial court's denial of the defendant's motion for copies of complete and detailed reports on any and all prospective jurors. Robinson citing Crawford v. State, and that's in 1972, Florida. Florida courts have therefore recognized defendant is not entitled to prior criminal history of potential jurors beyond the requirements of Brady. Assuming the defendant could point to some binding authority for the state to disclose this information, the defendant would still need to show due diligence in attempting to obtain it on his own before the court could require disclosure. The Florida Supreme Court has approvingly quoted the following when discussing a prosecutor's discovery obligations outside of Brady material. The underlying principle supporting the whole idea of criminal pretrial discovery as gleaned from the cases in well-reasoned commentaries is fairness. but no intelligent concept of fairness has ever been advanced which would require one side of a judicial controversy to prepare the case for his adversary or to furnish such adversary with evidence favorable to him when such evidence is otherwise reasonably available, and the unique aspects of the criminal law do not require that such a concept should be any more appropriate in a criminal case than any other. State versus Crawford, Florida 1972, quoting Gillespie versus State, Florida 2nd DCA 1969. Thus, before the court compels disclosure from the state, the court must first determine whether all or any part of the information sought by the defense is readily available to them through diligence, and whether the defendant has exerted and exhausted efforts to obtain the information. State versus Wright, Florida 4th DCA 2001. See also Yana versus State, Florida 3rd DCA 1975. A defendant should not be permitted to so employ the pretrial discovery procedures as to require the state attorney to disclose to him information or documents by which the exercise of due diligence are readily available to him. Put simply, the state has no duty to do for the defense work for which the defense can do for itself. State versus Counts, Florida 4th DCA 1981. The defendant cites no case law which supports the state is required to disclose prior criminal history, especially if defense counsel has demonstrated no efforts to obtain those records. With reasonable diligence, defense counsel will likely succeed in procuring the veneer member's arrest history and information from social media platforms. The Orange County Clerk of Court's website makes public records readily accessible, so any user of the website may search for a person's criminal history. A Google search of a person's name allows the seeker to view whether the person has any social media account. A juror's social media website can also be readily available to any user of the website, depending upon whether the account holder's privacy settings are public or not. The state assesses what is publicly available on social media sites. The information the defense seeks to compel from the state is equally available to the defendant through his counsel without having to compel disclosure from the state. Wherefore, the state requests this court to deny the defendant's motion for discovery of prosecutorial investigation of jurors. Yeah, so that's a motion for, hey, give us all you know about these potential jurors, and we don't want to work for ourselves. And Mr. William J. is like, get it yourself. I agree. All right. I mean, anybody can search on Google, right? And yeah, he's right. You can pull up all kinds of stuff online. State's response to defendant's motion for disclosure of penalty phase evidence. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. The state agrees to fulfill its obligations under Florida Rule of Criminal Procedure 3.220. 2. In Medina v. State, Florida 1985, the Florida Supreme Court noted that the defense has the initial burden of trying to discover such evidence and that the state is not required to prepare the defense's case. See also State v. Counts, and that's Florida 4th DCA 1981, holding that the state has no duty to obtain information for the defense that the defense is able to obtain by means other than production by the state. Yada v. State, Florida 3rd DCA 1975, noting that a defendant should not be permitted to employ the pretrial discovery procedures for disclosure of information or documents which by the exercise of due diligence are readily available to him by subpoena or deposition. State v. Wright, Florida 4th DCA 2001. 3. The Florida Supreme Court has maintained this position. Young v. State, Florida 1999. In Florida, defendants have the right to pretrial discovery under our rules of criminal procedure, and thus there is an obligation upon the defendant to exercise due diligence pretrial to obtain information. 4. The defendant should be required to follow the law and exercise due diligence during the discovery process. Certified, signed by William Robert J. See, these to me are so many, it's like they seriously are throwing things out. So, let's see. Let's see how many more we have left. So there's like about 19 left. So let's see if I can get through a couple more here. This one's not too long. All right. State's response to defendant's motion for disclosure of Brady versus Maryland materials of specific officers on list of law enforcement officers whose credibility is questioned by the Ninth Circuit State Attorney's Office. Sounds like it's the Brady list. Comes now the state of Florida by and through the undersigned Assistant State Attorney and states and alleges as follows. 1. The State Attorney's Office has closed to defense counsel any officer on the Brady list. Bingo. And our Osceola County's former Sheriff Marcos Lopez is on the Brady list, but he's not going to be called, so yeah, that's out the window. 2. As a defendant states in his motion, Florida Rule of Criminal Procedure 3.220b4 requires the state to disclose the existence of exculpatory evidence. 3. However, telling the defendant this information exists is different than retrieving it for him. Before the state can be ordered to gather this evidence for the defendant and provide it to him, the defendant needs to exercise due diligence to gather this evidence first. If he is unsuccessful, only then can the court order the state to gather this disclosed information for the defendant. It's like, yeah, do your work for yourself. We're not doing your homework. 4. In Medina v. State, Florida 1985, the Florida Supreme Court noted that the defense has the initial burden of trying to discover such evidence and that the state is not required to prepare the case. I think that one is one he's used a few times already, huh, guys? See also State v. Counts, Florida 4th DCA 1981, holding that the state has no duty to obtain information for the defense that the defense is able to obtain by means other than production by the state. Yana v. State, Florida 3rd DCA 1975, noting that a defendant should not be permitted to employ the pretrial discovery procedures for disclosure of information or documents which by the exercise of due diligence are readily available to him by subpoena or deposition. State v. Wright, Florida 4th DCA 2001. 5. The Florida Supreme Court has maintained this position. Young v. State, Florida 1999. In Florida, defendants have the right to pretrial discovery under our rules of criminal procedure, and thus there is an obligation upon the defendant to exercise due diligence pretrial to obtain information. 6. Therefore, the defendant's motion should be denied without prejudice. If he cannot obtain this disclosed information himself, he should then request the state to obtain it. If a dispute arises, he can petition the court for relief. Certified, signed, Mr. William J., Assistant State Attorney. That's my favorite one, I think. Do it yourself. You have a problem, we'll help you out. All right. State's response to defendant's motion for court reporter to note the race of all jurors examined during jury selection. Wow. What do you think of this one, guys? Comes now the state of Florida by and through the undersigned Assistant State Attorney and states and alleges as follows. 1. The process for analyzing whether a party is properly using a peremptory challenge is outlined in Melbourne v. Florida, Florida 1996. A party objecting to the other side's use of a peremptory challenge on a racial grounds must A. Make a timely objection on that basis, B. Show that the veneer person is a member of a distinct racial group, and C. Request the court ask the striking party its reason for the strike. B. At this point, the burden of production shifts to the proponent of the strike to come forward with a race-neutral explanation. C. If the explanation is facially racial neutral and the court believes that given all the circumstances surrounding the strike, the explanation is not a pretext, the strike will be sustained. Julemice v. State, Florida DCA 2009, quoting Melbourne. 2. This third step requires a record to be made, including such factors as the racial makeup of the veneer, prior strikes exercised against the same racial group, a strike based on a reason equally applicable to an unchallenged veneer person, or singling out the veneer person for special treatment. Julemice at 1204, citations omitted. Appellate courts have not hesitated to reverse a trial court's findings on the ultimate issue of pretext where the record does not support that finding. 3. The defendant states that the preferred approach to making the record is recording the race of all potential jurors examined by having each juror state his or her race during voir dire. 4. The defendant cites no authority as to who thinks this is the preferred approach. 5. The state has found no evidence that this is what is occurring in courtrooms or that it is preferred. Richardson v. State, Florida 5th DCA 2004, Mays v. State, Florida 3rd DCA 2022, Gordon versus State, Florida 2022. Joe Mice, Brandon versus State, Florida 3rd DCA 2021. Lafayette versus Moody, Florida 4th DCA 2021. State versus Johnson, Florida 2020. Dorona versus State, Florida 3rd DCA 2014. Wynn versus State, Florida 3rd DCA 2012. So he gave quite a few examples there. 6. The state suggests that the court wait until the need arises to do a Melbourne inquiry before asking all members of the veneer to identify themselves by race on the record. Hopefully no such objection will be made. However, if one is made, perhaps it can be resolved by the parties in the court agreeing that the potential juror belongs to a distinct racial group, and the genuineness of the striking party's explanation can be evaluated with the record of other veneer members' answers provided. If there is some sort of dispute over whether a potential juror appears to be a member of a distinct racial group, then the juror can be asked what he or she racially identifies as. 7. If all else fails, perhaps it will become necessary to ask particular members, or even every member of the veneer, whether he or she racially identifies as, but the state would suggest we not do that until the need arises. Certified signed, William J. I agree completely. Why do you have to look at somebody and go, can you please state your race? You know, come on. Really? I mean, I don't know what he thinks that's going to do for him, but I don't see it. Okay. And this one here is the state's response to defendant's motion for compensation of juror at current wages and for reimbursement to primary caregivers for daycare costs. I'm telling you, these are the most interesting motions I've read. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. A juror's compensation is a matter of legislative authority and not judicial prerogative. Paterno versus State, Florida 2nd DCA, 1980. 2. The defendant has failed to demonstrate that Florida Statutes 40.42 violates the fair cross-section of the community guarantee of the Sixth Amendment. In order to establish a prima facie violation of the fair cross-section requirement, the defendant must show 1. That the group alleged to be excluded is a distinctive group in the community. 2. That the representation of this group in veneers from which jurors are selected is not fair and reasonable in relation to the number of such persons in the community. And 3. That this underrepresentation is due to systematic exclusion of the group in the jury selection process. Duran versus Missouri, 1979. While the defendant's motion avers that the statutory compensation of jurors is practically impossible for wage laborers to serve on juries, there is no indication that these groups are actually underrepresented in the group from which juries are selected, or that they are systematically excluded, even if the courts were to recognize those as distinctive groups. 3. Therefore, the state requests the court to deny the defendant's motion. Yeah, that's weird. So, I don't know. I mean, I'm curious what some of you guys think of some of these motions, because I just feel like they're just out of left field, you know? All right. And this one here is state's response to defendant's motion for additional peremptory challenges. And I don't know why I can't continually say peremptory very well. So please don't bash me too much in the comments for my issues with stumbling over that word, please. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. While the defendant has a constitutional right to an impartial jury, there is no constitutional right to peremptory challenges. Peremptory challenges are a statutory creation. Jackson versus State, Florida 2017. 2. Florida Statute 908.13 specifically states that defendants facing a sentence of death or life in prison will receive 10 peremptory challenges. 3. Because there's no constitutional right to peremptory challenges, the state need only have a rational basis for the statutes in question. Fair and efficient trials is such a rational basis. 4. If during jury selection a need arises for the parties to request additional peremptory challenges, the court has the discretion to grant extra challenges. 5. Therefore, the defendant's motion should be denied. Certified signed, Mr. William J. All right, so I think we're going to stop there. And I think I can get through the rest of them on one more video. So this is going to be a 3-parter with all these responses to the defense's insane motions. I mean, not all of them are insane, but a lot of them are. They're pretty petty. So let me know what you guys think of these motions. I like that they're kind of short and sweet for the most part. A couple of them were a little long, but hopefully you guys don't bash me too much in the comments for stumbling over some of those words. I don't know why peremptory is it's like a word that's like, you know, certain words it's like you get tongue-tied. I don't know what it is. But again, let me know your thoughts. We are less than a month away from the first trial for the CSAM, the abuse trial. And you guys know I will keep you updated. I'm a little behind on the motions, but anything else that's urgent drops, that'll overshoot this stuff. So, and for those questioning, the judge has not responded about the cell phone and all that yet. So as soon as that happens, I will definitely let you guys know, and I will definitely do a video going through his response or responses. With that said, I hope you have a great rest of the day, and most of all, stay safe.